Falana, thank you so much for your time with us today.
Thank you very much. It's my pleasure.
So, the DSS raided the house of the Yoruba activist Sunday Igboho, admitted to killing 2 people, arresting 12 others. How did he react to the news of that raid and his subsequent arrest in Benin Republic by the authorities there?
Well, I was disturbed, like other Nigerians, when the news broke out that the residence of Chief Sunday Adeyemo, aka Sunday Igboho, was raided. And mark the use of the word raided by the State Security Service. I was more disturbed as a Nigerian, or as a Nigerian human rights lawyer, having consistently drawn the attention of the government and security forces to the relevant provisions of the Constitution, the African Charter on Human and People's Rights, and the Administration of Criminal Justice Act, and other laws that have provided or that have made provision, adequate provisions for the treatment of criminal suspects and other citizens in this country. i.e., that the rights of suspects be respected because they are presumed innocent until the contrary is proved by the state. Therefore, the question of invading the homes of citizens at night, waking up everybody in the neighborhood, shooting and killing people are not acceptable under the current human rights law regime in Nigeria. And it's been a tortuous journey to arrive at the point, where we are. In other words, nobody, and I'm saying that the government should not arrest any suspect if he or she is reasonably suspected to have committed an offense. But under the law, Section 2, subsection 10 of the Anti-Torture Act stipulates that denial of sleep or rest is an act of torture which has been criminalized and prohibited in Nigeria. That means unless a criminal suspect is involved in contravening the law at night, you cannot pounce on him or her. You must wait and allow the day to break before effecting an arrest. But when you announce that a raid had been carried out in the home of a suspect, 2 people have been killed, 12 people have been arrested, a search has been conducted, seizures have been made, in the dead of the night, there are problems. And so, I was worried that we are back to the era of military dictatorship, where such practices were the order of the day.
And a subsequent arrest in Benin Republic by the authorities, how did you receive that news?
Yes, I read that Igboho was arrested together with his wife at the airport in Benin Republic, in Cotonou, Benin Republic, on his way to Germany, or their way to Germany. And of course, because there was already a red alert issued by the Interpol, according to information, they were arrested. Again, there are some lessons to learn from the development in Benin Republic. After the arrest of the couple, 2 days later, they appeared in court. And the court found out and came to the conclusion that the wife committed no offense and that no request has been made for the arrest of the wife by Nigeria. And so, she's been released. The court ordered her immediate release from detention. While the court heard the arguments of the prosecutor in respect of the allegations made by Nigeria, said, okay, we're going to give her a ruling on Monday. Why I'm saying that we have some lessons to learn from the development in that country is that Benin Republic has said, we are going to go through the gamut of our criminal legal system. We're not going to release Igboho at the mere request of Nigeria. Here, we operate under the rule of law. And the rule of law must, the law must take its course.
So far, so good. Benin Republic is on the right track.
For sure. In the case of Nigeria, those who were arrested, the 12 people arrested in Igboho's house, on the 1st of July this year, have not been taken to any court. They have been detained incommunicado. Nobody has been allowed to see them. Their lawyers, their relations, nobody has been allowed to visit them, contrary to the provisions of Section 6 and 7 of the Administration of Criminal Justice Act, to the effect that nobody in Nigeria shall be arrested in lieu of another person. You can't say, because you cannot find Mr. Falana, when you visit his home, you arrest the wife or the children. No. That is no longer part of our law. 2, the moment a citizen or anybody is arrested and taken to a police station or a detention facility at the expense of the state, the next of kin, or a family member, or the lawyer of the suspect shall be contacted by the detention agency or the officers in charge of the detention facility. So the question of looking for suspects to find out where a suspect is detained is no longer allowed by law. If you have no lawyer, the government, the police station, or the detention facility shall contact the Legal Aid Council to provide a lawyer for you. That is the position of the law in Nigeria today. These rights have been abused contrary to what is playing out in Benin Republic. The only disturbing aspect of the development in Benin Republic is that Igboho is said to be handcuffed in the police station. No. Again, I am aware that Benin Republic also operates under the African Charter on Human and People's Rights. Article 5 stipulates that everybody, including criminal suspects, shall be treated with dignity. So you cannot treat a suspect who has not been indicted or convicted of an offense. You cannot subject him or her to restrain, via handcuffs. So you can't detain somebody in a cell, leg chains or handcuffs. No. And I'm aware that East lawyers have protested to the authorities in that country. But I'm just saying that our own law, the Constitution of Nigeria, Section 35, subsection 4, provides that anybody who is arrested shall be taken to a court of law within 24 hours if in the place where he was arrested, there is a court within a 40-kilometer radius. If it is beyond a 40-kilometer radius, it shall be taken to court within not more than 48 hours. If the person is going to be further detained, to allow for investigation, there must be a remand order made by a court. So that is the law here. But these provisions are being abused.
Let's go back to Benin Republic now and the way that the authorities there are handling the case and the way it's being put forward. So we hear that the Nigerian government has asked that he be held because he has committed some crimes in Nigeria. The charges against him are inciting violence, stockpiling arms, and also his secessionist, what they say, his secessionist activities. If you were his lawyers, what argument would you be putting forward?
I don't deal with suppositions like media, people. I would rather deal with a life issue here. To the best of my knowledge, there's no extradition treaty between Nigeria and Benin Republic. In spite of our demand for the domestication of the ECOWAS Convention on Extradition, the government has refused to do the needful. Here we are again. So far, the government of Nigeria has not packaged its request, has not made a request to the government of Benin Republic. What I was made to understand was that, or is that, Sunday Igboho's name was on the watch list of the Interpol. And contrary to the belief in official circles here, the Interpol does not involve itself in the deportation or extradition of suspects. All that Interpol does is to mobilize local security people to arrest a suspect wanted in his or her country, pending legal surrender or extradition. And what has happened in this case is that, from what I read, the Nigerian ambassador to Benin Republic, I think retired General Yusuf Buratai, was said to have written a letter to the Benin authorities for the extradition of Igboho. Well, that's not acceptable under international law. Even though Nigeria has not domesticated the ECOWAS Convention on Extradition of 1994, it is binding on Benin Republic because its own constitution does not require domestication. Therefore, under the convention, there must be a request submitted to a member state of the ECOWAS, setting out the charges or the offenses allegedly committed by the suspect with detailed facts and figures, the nature of the evidence, and or rather, provided that the offenses are not political in nature, extradition can take place. But the convention recognizes the right of the requested person to be represented by a lawyer of his or her choice, who will adduce evidence and advance arguments to prove or show why person affected should not be deported or extradited. That is the position of the law. Yeah. And I think that is what is going on in Benin Republic.
Yes, so like you rightly said, from what we hear, the Nigerian government has not asked for him to be extradited.
No.
So
no, Nigerian government has asked outside the ambit of the law.
Yes, but
the law requires detailed.
But that has not been done
A
yet.
request has to be made. Yeah.
That has not been done yet.
No request has been submitted so
what
far.
is on ground is the fact that the Nigerian government has asked that he be held because he committed some crimes in Nigeria.
Yeah.
So when they go back to court on Monday, what do you think will play out? How do you see things playing out?
Some submissions have been made. The court is going to rule as to whether there is sufficient material before the court to continue to hold him. Because under the ECOWAS Convention, I'm aware that a requesting state has up to 20 days to submit a request for extradition. And if that is not done, the person involved is entitled to his or her release.
So after 20 days, there's a likelihood if Nigerian government can't prove this charges or this allegations against him, Igboho will be set free.
For sure.
Okay, so let's talk about...
And again, this point has to be made abundantly clear. Nobody is saying that Nigeria, the government of Nigeria, has no right to request for the extradition of Sunday Igboho. But it has to be done in strict compliance with the law of the Benin Republic and international law. If the government succeeds, it's brought to Nigeria for trial. If it fails, it will be released and allowed to continue this journey. Yeah.
Let's go back to the raid on Sunday Igboho's house because there have been talks and people have different opinion as to what should have played out after then. Sunday Igboho's house was raided and he went under the radar. The DSS declared him wanted. Some people would have argued that he should have stayed back and turned himself in.
From the facts and circumstances of the arrest, of the raid, he was lucky to have escaped. If two other people were killed, who were not accused of any offense, he might have been killed. Because he was the primary target. Having escaped in such a violent attack on his house. Yes, the State Security Service asked him to claim to have declared him wanted. Again, was that in accordance with the law? In the case of Benedict Peters and the EFCC, the High Court of the Federal Capital Territory ruled that in Nigeria, no criminal suspect can be declared wanted without a court order. Unless a suspect is committing an offense, it cannot be arrested without a warrant of arrest. If you want to search the house of a criminal suspect, you must be in possession of a search warrant. So far, these clear provisions of the law were breached by the State Security Service. And the question that Nigerians are not asking is, who has the power in Nigeria to arrest criminal suspects alleged to be in possession of arms and ammunition, alleged to be involved in treasonable felony, and so on and so forth? It is the police. The State Security Service has no power under the law. Under the law. Today, unless the law will be amended tomorrow, to exercise police powers. The EFCC is empowered to exercise police powers. The NDLA is empowered to exercise police powers. The ICPC, the Federal Road Safety Commission, and so on and so forth, and other law enforcement agencies are empowered by law and writing to exercise police powers, which will include the power of arrest, of investigation, and of arraignment of criminal suspects in court, subject to the power of the Attorney General, either of the Federation or the state, to take over. But I'm saying, as far as the human rights law regime is concerned in Nigeria, the State Security Service does not have the power to invade the home of any citizen and effect an arrest. That's the position of the law. And I think a respected senior advocate of Nigeria, Are Afe Babalola, wrote an opinion on this matter, which was published to the effect that the State Security Service does not have the power to arrest any suspect involved in a criminal offense in Nigeria. I'm aware that under the Police Act 2020 or under the Police Act of 1990, it is only the police, based on information passed from the State Security Service, that can effect the arrest of a suspect. By the way, the law has not created DSS, Department of State Service. No. The law has created a State Security Service. It is not a department in the presidency. It is the State Security Service that has been created by law. In fact, and this is our experience, if you file a case against the DSS, the lawyer of the State Security Service will file an objection that DSS is unknown to law. And in many cases, the court has struck out such matters. So I therefore wonder why the agency continues to refer to itself as a DSS. Or why you people in the media continue to refer to that, the State Security Service, as DSS. So we just have to return to the path of rule of law and constitutionalism. And that is the point I'm trying to make.
Sunday Igboho had again and again proclaimed his innocence. He said he was standing up for his people who were being attacked, raped, and sometimes killed. Were his methods legal? Did he break any law?
And I'm not in a position to express an opinion on the charges against him. It will not be fair, to be prejudicial, really, to his right to fair hearing. Right? I personally had cause to express disagreement with his method openly. I disagree with him when he gave a quick notice to the Fulani people to leave the Southwest. I disagreed with him through your medium. And that was not the first time I'd expressed disagreement with those who gave quick notices. When a fellow gave a quick notice to a 7-day quick notice to the Igbo community in the north to leave the north within 1 week, in 2017, I came out publicly against such illegality. When some young people in Sokoto State gave a quick notice and asked the Catholic Bishop of Sokoto Archdiocese, Bishop Matthew Azan Kuka, to leave the state because he had criticized the Buhari administration. I kicked against it. Because for me, we must never be pushed to engage in ethnic profiling. For me, every criminal suspect, regardless of his ethnic extraction or religious persuasion, will have to be arrested and dealt with under the law. I have been worried I've been worried that some criminal suspects arrested and handed over to the police were not prosecuted in Igongon area of Oyo State. And what we have done, my comrade, and compatriot, Mr. Femi Aborishade, approached me, because he also comes from that area of Oyo State, that he wanted to go to court. We are in court to enforce the right of everybody in Igongon area to life and the security of their property. So we have approached the federal court. We have sued the federal government and the state government, or your state government, to provide adequate security for the people in the area. So that was the basis of my disagreement. But notwithstanding my reservations with respect to its method, right, I have a duty to ensure that the government, which owes a greater responsibility to the people, does not engage in the violations of its fundamental rights to liberty, to fair hearing, and so on and so forth. No, that's the basis of my, opposition to the method of the government.
So let's move on to another story that was a big story, still a big story in Nigeria, the arrest of the leader of IPOB, Nnamdi Kanu. The federal government called it a joint effort. The arrest was made possible as a result of joint effort with security operatives, but his lawyer called it an extraordinary rendition. What do you call it?
What I call it is irrelevant. What is relevant here is that once a criminal suspect jumps bail, and the court and the trial court has issued a bench warrant for his arrest, is liable to be arrested. But it has to be done under the law. In this case, it has been established that Nnamdi Kanu had left the United Kingdom, where he was staying, and that he was abducted in Kenya and brought to Nigeria against his wish. That is not longer acceptable under international law. That is gangsterism, which must not be associated with any more than state. Under the Extradition Act of Kenya, the bench warrant issued by the Federal High Court should have formed the basis of the request for its extradition. And all that is required in that country is that the extradition proceeding be filed in a magistrate court in Nairobi. And the court will have ruled one way or the other. The government cannot be too much in a hurry to bring a criminal suspect to book. No! The government has all the time of this world. If it's going to take you 5 years or 10 years to pursue your right under the law, so be it. A few years ago, a man approached us crying, "What can we do for you?" His wife had traveled with his 6-year-old son to the United States. Unfortunately, the lady lost her life in the US. So her sister and her husband decided to adopt the boy. His father lives in Nigeria. At that time, his 4-year-old sister was also here. And so we approached the Lagos High Court. We filed an action in the Lagos High Court against the members of the family of the deceased, together with the sister and her husband in the United States of America. And the court gave an order that the boy be brought back from the United States of America to join his father and his sister here. We contacted the lawyer in the United States of America to register the judgment of the Lagos High Court. And as soon as the judgment was registered, the government of America ensured that the boy was brought to Nigeria. So this is a position in international law. In the last, on June 12 last year, at the request of the United States government, a Venezuelan diplomat was arrested in Cape Verde, in West Africa, on June 12. Up till now, the matter is still being pursued in the domestic court. Meanwhile, the ECOWAS Court of Justice has ruled that his arrest was illegal and that he be released and pay $200,000 reparation, and that the extradition proceedings be quashed. Cape Verde says, oh, we're not banned by the ECOWAS supplementary protocol on the court, and therefore we're not going to obey the order. We are in court. We've dragged Cape Verde to the United Nations Human Rights Committee. The Human Rights Committee has said, stop further action on the extradition. You must allow us to determine this matter. So international law has gone beyond where the government of Nigeria, is operating. And that is why we appeal to the government not to continue to embarrass the country. Up to now, the government of Kenya cannot, up to now, admit that Nnamdi Kanu was abducted in that country, because there will be a problem. The human rights community will not tolerate it in that country. The global human rights community will not tolerate it. And that is why Kenya cannot say publicly, oh, we're party to what type of international collaboration will allow abduction of a criminal suspect, rendition? No, it's not acceptable. And that is why you have extradition laws and extradition treaties between states. In 1962, the late Chief Tony Nahoro had fled the country, was located in the United Kingdom. Nigeria at that time submitted a request for his extradition. Extradition proceedings were filed in a London court. The late Nahoro lost the case and was brought to Nigeria for trial for treasonable felony along with Chief Ababi Mawolowo and Co. So if we could do that in 1962, how can Nigeria in 2021 be associated with gangsterism in international law? So this is the point we're trying to make. The government must be patient. The government must take its time. The government must be properly advised and ensure that the rights of suspects are respected. And this is beyond Kanu or Igboho or anybody. Because it can be anybody's turn tomorrow. And that is why the law must be interpreted at all times in favor of justice and fair play.
So finally, this act of gangsterism, as you called it, by the federal government, do you see it throwing a spanner in the wheel of things, if you like, for the federal government when Nnamdi Kanu's trial commences on Monday?
Again, I am not in a position to comment on the trial because it is pending in court. On your part and mine, it will be contempt ex facie curia. So we must allow the court to deal with it, and we must allow its lawyers to file the necessary applications for the determination and the consideration of the court. I think we are going to learn a lot from the two cases, the case of Nnamdi Kanu in Nigeria, and of course, I also believe in Kenya and Benin Republic, so that at the end of the day, the government can go back to the drawing table and learn to do it properly. I mean, in 2003, a notorious criminal suspect who was alleged to have been involved in trans-border crimes between Nigeria and Benin Republic, Nnamdi Kanu, was abducted physically in Benin Republic by a team of the Nigerian police force and brought to Nigeria for trial. That was in 2003. But for the fact that, yes, he was standing trial in Lagos, before the Lagos High Court, when he lost his life in Kirikiri maximum prisons. Now, Kirikiri Correctional Center. I'm sure if he had survived, he would have dragged Nigeria, before the ECOWAS court. It was in the ECOWAS court earlier, and the court said, no, since you have been brought here for trial, there's nothing we can do, right? But that does not stop the court from addressing the violations of his human rights. So I think these are lessons for us as a people, so that Nigeria is not censored, or you do not lose the opportunity to try a criminal suspect by the method, of arrest and rendition and so on and so forth. So for me, I think at the end of the day, Nigeria will have gained tremendously from these cases.